COPWATCH, policing the police every single day.
Wonderful to have you back. All right. Well, I mentioned that the Supreme Court has been busy. The Supreme Court was busy even this morning. The much-awaited Carpenter decision has come out. So let's start with that. We've talked about this case before on This Week in Law. It has at its crux whether law enforcement has to get a warrant in order to get cell site location data to use to charge someone and use as evidence in prosecuting someone for a crime. And just this morning, the United States Supreme Court has issued its decision in this important case. And in a very close 5-4 decision, the court decided, yes, indeed, a warrant is required in order to maintain or obtain, that kind of data from a cellular company. So this case involved some folks that were involved, hilariously enough, in stealing cell phones. They were going around hitting Radio Shacks and other stores. The police apprehended one of the lower people on the criminal enterprise, who then pointed fingers at the ringleader, Mr. Carpenter. And in order to obtain evidence against Mr. Carpenter, law enforcement obtained somewhere upwards of 120 days of his cell site location data, which pinpointed his location within half a mile to 2 miles of accuracy every time he his cell phone connected with a cellular tower as he moved around. And lo and behold, these locations were pretty close to where the crimes were taking place, and that was used at his trial, and he was convicted. Appeals ensued. The Supreme Court got involved, and this morning we have a decision with a majority by Justice Roberts and 4 different dissents by the dissenting justices, deciding ultimately that a warrant and probable cause, which is necessary to get such a warrant, will be required in future to get this kind of data for law enforcement. In most cases, there are a couple of narrow exceptions, which we will discuss. So let's start with you, Mike. Were you surprised by today's decision?
I kind of was, not so much in the decision itself. I mean, I haven't had a chance to really dive in. It's about 119 pages, all the various opinions out there. But the thing that struck me kind of right off the bat, we've talked before about Justice Gorsuch and his opinions when he was a circuit court judge. He was a fairly, I'd say, protective of Fourth Amendment rights. We talked about a couple of opinions in particular that he authored as a circuit court judge. Kind of surprised to see him in the dissent here with Chief Justice Roberts writing for the majority. So right off the bat, that kind of surprised me given what we've talked about and discussed with respect to Gorsuch previously. But always fascinating this time of year to see these big decisions come out. This is obviously a very significant one for law enforcement officers, and it's really significant. And again, another 5-4 decision just shows how closely divided this court is. Pretty fascinating stuff.
It is really fascinating stuff. I do think it's interesting that the court here was held to a higher, or the court is going to hold law enforcement to a higher standard than they had to use in this case. In this case, they didn't just go willy-nilly to the cellular provider and say, turn over your data. They did have legal authority behind them. They used the Stored Communications Act as their foundation for saying we have authority to obtain this data for you. But that is a lower standard and did not require a judge to vet the law enforcement claim that they needed the evidence as does a warrant requiring probable cause. Probable cause basically means that the evidence that the law enforcement officers are seeking is likely to provide evidence that a crime took place. So they have a fairly, I mean, it's not that hard to get a warrant, but it's a higher standard to meet than the one they did in this case. And what seemed to be really important to Chief Justice Roberts, writing for the majority here, was, again, this recognition, and we've seen this pattern in a few different cases from the Supreme Court over the last several years, this recognition that technology has fundamentally changed the way we need to think about the Fourth Amendment and the way that our lives work now. I mean, they basically acknowledged that a cell phone is a necessity of modern life and we're all carrying them around, and yet we have not forfeited our expectations of privacy merely because of the way these devices that we're carrying work. So I think that's an important note for the court to hit here. What did you think, Lisa?
Well, I'm just reading the headlines. Like Mike, I haven't worked my way through the reasoning of the entire opinion, but my reaction is generally one of relief, but also feeling like it was a close call, no pun intended. It's very important that the Supreme Court interprets the Fourth Amendment and expectations of privacy in light of current prevailing norms. And the more that we're dependent on our mobile devices, the more important it is to keep a balancing of certain safeguards. I mean, in reading some of the other news stories in the rundown, it strikes me that just requiring a warrant to obtain physical location records is not a tremendously burdensome standard. I mean, all kinds of federal judges are ordering all kinds of things that have just monumental impacts on large swaths of our population. So I feel a sense of relief that I think that this is the right outcome, and I do look forward to reading the entire opinion.
Yes, the opinion, we should say, just came out this morning, and as Mike pointed out, is really lengthy. So we're attempting to pass along our thoughts to you without the benefit of diving into it in any great detail. We're simply thankful for the people who have done so quickly this morning and have already published their thoughts. And we just wanted to be able to let you know that this long-awaited decision has come out and that it has been in line with some other recent decisions of the Supreme Court that seem to be recognizing the importance of maintaining Fourth Amendment standards in the era of things like GPS trackers that can be applied to your car and cell phones that we all carry around. I had just read an article yesterday that I thought was really sort of timely based on the decision coming out today. And in fact, we have some other stories that we'll talk about in a different context in a bit in the show, talking about Generation Z, which I guess is what we're calling today's teenagers, 13 to 23-year-olds wandering about in the world today, and the way that their devices are a part of their lives, which is, I think we're all welded to our devices, or we think we are. We don't function very well without them. But this new generation has never functioned at all without them from the time that they were, maybe 10 to 12 years old through what will be the rest of their lives. And this piece at Global News in Canada sort of pushes back on the notion that this new generation is addicted to their devices. And instead, one of the folks quoted in this piece says, it's not an addiction. It's an extension of themselves. Are you addicted to your right hand? And having one of these in my household, I can tell you that truly is the experience that I see my son and his cohorts having. That it's not so much, they can't or won't put the devices down. They simply see it as such a resource for their lives that why would they? it's literally like cutting off an appendage that you need to function well in the world. So I think that recognition, I don't know if I don't think the Supreme Court probably read this piece, but I think that sort of theme definitely comes through in the analysis here that, it's not so much a choice to be using these tools, and nobody certainly chooses how they function, and the fact that whenever they connect to a cell tower, there's a record of your location. So it seems like that played a pivotal role in the analysis here. Another thing that I thought was quite interesting was that Professor Oren Kerr, who is one of the great legal scholars of our era here, weighed in on the side of the government and submitted a brief that the dissenters found compelling, but that Chief Justice Roberts said, I see what you're saying, but not going to agree with you. And it had to do with reasonable expectations of privacy. When you walk to the store, your neighbors can see you walking to the store. People you don't know can see you, and they can be called as witnesses to say, yes, that this person was in this location at this time. But Chief Justice Roberts wasn't ready to lump cellular companies and their towers into that kind of bucket, and said, no neighbor is as vigilant as these cell towers are, and there's no real appreciation among the general public of how closely they're being tracked. So to get at that data does really thwart how people think that their privacy interests are being represented in the world. Mike, do you have any other thoughts?
No, I mean, I agree that analogy just doesn't hold. I mean, even the nosiest of neighbors aren't going to be on 24/7, able to track and monitor your whereabouts, no matter how vigilant or diligent those neighbors are. So yeah, I agree with Justice Roberts. That just doesn't really hold water for me. I think this is it's a significant decision. Obviously, I do wonder about how big of an impact from a day-to-day perspective with respect to law enforcement it is. As Lisa was pointing out, look, you can get a warrant. You have to show probable cause. You don't have to show it's not a tremendous showing that you have to make. And so it seems like this is more or less maybe a little bit more time consuming for law enforcement officers, but I'm not sure that other than that, it's going to be a significant burden. And it's a pretty significant victory for data privacy advocates and others. So those are my thoughts.
Right. It might be worthwhile to contrast the two standards, the ones that the officers used here under the Stored Communications Act required them to demonstrate specific and articulable facts showing there are reasonable grounds to believe that electronic data being sought is relevant to an ongoing criminal investigation. So that might sound a lot like, oh, well, isn't that what you have to show to get a warrant anyway? No, to get a warrant, you have to show facts that support an objective belief that the person to be arrested has committed a crime. So it's beyond just helpful to the investigation. It's that what you're going to find out will help cement, and there's objective, reasonable basis to think this will help cement that they committed a crime. Or that the place or the item to be searched bears evidence of a crime. And a judge has to vet that and agree, yes, there's probable cause, and yes, you can go get this stuff. So warrants issue all the time. They're not, it's not a terribly hard standard to meet, and law enforcement is certainly used to doing it in other contexts. So I don't see this as a huge, thwart or roadblock to investigations. It's a check in the process. But
yeah,
go ahead, Lisa.
Remember how much trouble they had getting a warrant in The Wire, and it's a really big deal if the government wants to start wiretapping and listening in to your audio conversations. So to just have a different standard for basically following your physical whereabouts around, I mean, it doesn't seem that it would fit into existing Fourth Amendment law that easily to create such an exception. I was just thinking of how this fits with your analogy of the neighbor and thinking about the old plain sight doctrine. You know, I mean, if it's in plain sight, sure, that can start leading to probable cause, but it is different. Something like using technology that everyone depends on for other day-to-day necessities to then conduct surveillance with a lower level of scrutiny than they would need to listen in on your actual conversations, for example.
Right. So what people might be wondering is, oh, so if this evidence was bad and there was supposed to be a warrant and there wasn't one, does that mean this criminal who was turned in by his underlings and going around hitting Radio Shacks, is he going to be let go? And it doesn't look like that will be the case at all. Timothy Carpenter was the suspect in question here, because there is a different part of the Fourth Amendment that says if law enforcement obtained the evidence believing that they were acting according to legal authority, it's still admissible even if the law changes afterward. So this isn't going to go back and undo necessarily his conviction, which, it's sort of bittersweet, I guess, to win your Supreme Court case and have it mean that you're still going to do your time. But I have I don't know all the context of who came in and represented Timothy Carpenter and why, but it really seems like maybe he got legal representation here from someone who wanted to take this case to the Supreme Court if possible and make this kind of precedent, not necessarily because Timothy needed to be set free. So we'll have to see exactly what happens with him after the fact. Any final thoughts, Mike?
Nothing here. I think you've exhausted my thoughts on this one.
All righty then. Lisa, anything you want to add?
No, I look forward to reading the actual opinion.
Yes, as do we all. And I bet the dissents are going to be really interesting too. 4 separate justices giving their different thoughts on it. All right, that's not the only thing. We're down here at the end of the Supreme Court term. They have a bunch of things that they need to get done so they can conclude the term that started in October. The other case that came out yesterday undid a case that we've talked about on the show before called Quill. And this is the case that involved whether online retailers have to charge sales tax. And the decision this week, again, another 5-4 decision from the Supreme Court that just came out yesterday, says that states can make online businesses collect sales taxes even if they have zero physical presence in that state. That's been kind of the kicker for a while and the confusion about this. So states can require online retailers now to charge sales tax in their states. This isn't really going to impact the major players because they have been voluntarily complying. They caved to state pressure some time ago and collecting sales taxes voluntarily, even though this law was unsettled in states like California and Colorado, et cetera, states that have gone to them and said, hey, you need to do this. Because the default, if the retailer doesn't do it, is that the purchaser is supposed to keep track and pay those sales taxes with their tax returns. And that is honored far more in the breach than in the keeping. So, Amazon and others are well positioned to deal with this Supreme Court decision, but it's the smaller players the very small online retailers, targeting niche audiences and trying to expand to be in Amazon someday, maybe, or just to be successful, who are really going to have to know, okay, different sales taxes apply in all the 50 states, and boy, this is going to be a large undertaking for a small business, or even, a small mom and pop kind of shop. So my prediction about this is that the small businesses are going to band together and convince their elected representatives that we need some way to make it easier for them. We need some sort of uniformity that gets around and runs the fact that complying with each individual state sales tax law is going to be pretty onerous. What do you think, Mike?
Yeah, I mean, this is a very significant decision for smaller players in the market for the exact reason that you're mentioning. I think that prediction is a good one. I mean, in order for them to really compete in the marketplace, I mean, this is going to be a tremendous burden. I mean, you can imagine a small mom and pop shop that doesn't have any physical presence in 49 of the 50 states. Now they're subject, but still sell their goods over the internet into those states. Now they're going to be subject to collecting sales tax on all of those sales and remitting it to the various state agencies. I mean, it's just what a headache and what a financial burden. So, something's got to give. It's either in the short term they're just not going to do it to a large extent, or at some point they're going to have to try to force a change here to make it a bit more sensible. Because I think it was Justice Roberts in his dissent. It was Justice Kennedy in the majority in this one, Roberts in the dissent. He was saying, look, this is really going to adversely affect in a very significant negative way all of these small retailers that are out there trying to sell their beads and other things, as Justice Roberts said. So pretty this has got to be pretty upsetting to all those small retailers.
Yeah, and I mean, backing off my prediction somewhat, it's one of those very primary things that are reserved to the states is how much tax they're going to charge for items sold to their residents, and for the federal government to be able to come in and say, thou shalt charge 6% to make everything uniform. That's not going to fly very well, but they've got to do something. There's got to be a way to make this not the burden that we think that it is likely to be, and Justice Roberts thinks that it's likely to be. Lisa, do you see any light at the end of this tunnel?
Sure. I mean, if I'm going to take the contrary position, first of all, physical retailers.
Police use who may want to retaliate against him physically.
Hey Charlotte County, this is Charlotte County COPWATCH, and I just wanted you to know that I am using this stuff under fair use. And also remember to like and subscribe this channel. Also too, keep in mind I do not make any money on YouTube. This is 5 hours work a day, fighting for freedom. And you can donate with PayPal and Patreon. I just want you to think about this. If everybody gives to PayPal and Patreon, Patreon is every month. Actually, PayPal you can do every month. I have 12,000 subscribers. If everybody gives, I can quit my regular job and go full-time investigations on Charlotte County, and possibly even more and beyond. So just keep that in mind. If everybody helps out, I can go full-time doing this. Thanks.